The debate this afternoon is on extradition. I call Mr. Dominic Raab.
Thank you, Mr. Rosendale, and it's a tremendous pleasure and privilege to speak under your chairmanship, and for me the first time, I believe. I would also like to just thank the Backbench Business Committee for allocating time for this debate in Westminster Hall, and I certainly welcome the presence and the participation of the Immigration Minister and thank him in advance for engaging so proactively on such an important issue. Mr. Rosendale, the Home Office is often berated for letting too many people into the UK, so it's something of a novelty for ministers to face the reverse criticism. And yet, as the Joint Committee on Human Rights, of which I'm a member, has pointed out in its most recent report on extradition, there are real flaws and widespread concerns about our extradition laws. There are concerns about the UK-US Extradition Treaty 2003, which as a result of Article 8, paragraph 3, subparagraph C, sets different evidential thresholds for the two respective countries. The United States didn't ratify the treaty until 2007, but just for clarity, my understanding is it has relied on the lower burden of proof available to it since 2004. Now, lawyers can bicker about whether or not there is a substantive difference between the requirement for the US to satisfy the reasonable suspicion test compared to the requirement that the United Kingdom show probable cause. But the fact is, in operational terms, since 2004, 24 Britons have been extradited to the United States under the new arrangements. Just one American has been extradited to Britain. In practice, as it affects our respective citizens, the arrangements have been practically all one way. That said, I have to say, in my view, and others will speak to their individual cases and of their constituents, that the main problem has been the absence of any discretion that would allow the UK to decline extradition in cross-border cases, having taken into account the interests of justice. That's the problem presented in the case of Gary McKinnon. Less, or if not equally, the issue of the alleged offence or the evidential threshold, but more the injustice in dispatching a young man with Asperger syndrome hundreds of miles from home on allegations of computer hacking, someone who was apparently searching for UFOs. More misfit than terrorist, he should not be equated with some high-level Al-Qaeda suspect or gangster. I give way.
On securing this incredibly important debate and at an early stage raising the case of my constituent Gary McKinnon. He's already raised the issue of disparity. Does it not seem self-evidently a disparity in terms of statistics that I understand in the last 40 years there have been three suspected terrorists from the United States who've been extradited to this country in comparison to the situation facing Gary McKinnon, who's been prosecuted on the basis of alleged terrorism?
Well, I thank my honourable friend for that historical context. I certainly accept it. I think it's very important to have that practical, operational background in terms of the numbers of cases so that this doesn't become a dry lawyers' debate about the terms of the treaty or the Extradition Act. We have the legislation in place to inject a dose of common sense discretion in cases like the McKinnon case and others. The government ought to bring it into force as a matter of priority. I should just say at this stage that I do understand the US concern. I've spoken to officials from the US Embassy and I understand their concerns in relation to the operation of the treaty, and they make quite strong arguments about the issue of the discrepancy between the evidential threshold. But nonetheless, the fact is that in their extradition treaty relations with, let's say, Brazil, Mexico, Australia, to name but a few, the domestic authorities of those respective countries have the right to decline extradition in these and much, much wider circumstances. So why shouldn't Britain, a stalwart ally, request such a modest adjustment? In reality, Mr. Rosendale, the problems created by the European arrest warrant have proven even more serious and far more widespread than those under the US treaty. First, there is the kind of case that we have exemplified, illustrated by that of Andrew Simeo. Andrew, a British student, was whisked off to Greece under a European arrest warrant for involvement in a fight at a nightclub that left another man dead, a very serious offence. But he was extradited despite eyewitness accounts that Andrew was not in the nightclub at the time. Now, fast-track EU extradition is based on the assumption that standards of justice are adequate across Europe. We all put our faith in that trust and that assumption. And I'm afraid that the Simeo case and many others show that that assumption is a sham, it is a fraud, and we cannot understand the operation of the AW without understanding the fraud that is this assumption that all of the justice systems operate in a similarly or to a similarly high standard. Let's look at the Simeo case. Greek police beat identical statements out of witnesses that were then retracted. Andrew Simeo spent almost a year in squalid prison conditions before being bailed. He was left with a flea-ridden blanket in a cell exposed to a sewer, crawling with cockroaches. He was abused by guards. He witnessed another prisoner being beaten to death for drug money. And the trial itself proceeded at a snail's pace without court translators who speak, with court translators who speak very little English or scant English. He was eventually cleared in June of this year after a 2-year ordeal, and he's left to rebuild his life. Now, the independent Baker Review, commissioned by the Coalition to look into the operation of our extradition relations, makes absolutely no recommendations for preventing such horror stories being inflicted on other innocent people. And I use the word innocent advisedly. It's clearly the case in the case of Andrew Simeo. The Simeo case highlights the need for a higher evidential threshold, the prima facie test, to mitigate against the risk that fast-track extradition goes ahead on manifestly tainted evidence or spurious grounds. Now, the Baker report merely suggests that over time and with effort, the justice systems and prison conditions across Europe will get better. Now, we may well hope for that, all of us in this room, but the fact is that it is naive at best and reckless at worst. And I urge the government to ignore what is a very legalistic and simplistic analysis and just think what innocent people like Andrew Simeo actually went through in real life. I give way.
I'm grateful for him giving way on this point about my constituent, and I too congratulate him on this debate. Would he not agree, before he concludes his comments on Andrew Simeo, that many of the fundamental breaches of his human rights whilst in prison that took place, unfortunately the Scott Baker report makes it clear that they believe, because there is mutual recognition and all EU members have signed up to the Human Rights Act, that therefore we are not right to presume any fundamental breaches of human rights.
I thank my honourable friend. That is exactly the point. That is exactly why the assumptions that underwrite the European arrest warrant are fraudulent. I can't think of any other way of putting it. And I think, just going back to the Baker report, it is not good enough just to sit back and hit and hope on the Greek justice system getting better. For one thing, it may actually be getting worse. Transparency International's Corruption's Perception Index is one very well-regarded measure of standards of justice in national administrations and legal systems. On a score of 1 to 10, 1 being the most corrupt, Greece has actually fallen from 4.2 to 3.5 in the last 10 years. Now, even if there were grounds for optimism that the Greek justice system will improve over time, and that's what we all hope, we need to protect our citizens right now. Not in 5 years' time, not in 10 years' time, but today. And that is why we need an amendment to the European Arrest Warrant Framework Decision, a prima facie test, along with the proportionality safeguard, as well as the other recommendations made by the Joint Committee on Human Rights. In fairness to the Baker Review, it did acknowledge the case for an amendment to the European Arrest Warrant to accommodate a proportionality test, and that is one of the crucial other safeguards that I think needs to be brought into place. But in other areas, the report ignores almost wholesale major flaws in the current arrangements. It casually disregarded the evidence that warrants are being issued for the purposes of investigation rather than for prosecution. It's a very important point. And it's best illustrated, in my mind, by the evidence given by Michael Turner to the Joint Committee. This is someone who set up a property business in Hungary in 2005, and when it failed, as some business ventures do, he paid off his staff, he filed for bankruptcy, he returned to Britain. 3 years later, he was extradited back to a Hungarian jail, accused of defrauding on certain administration fees. He was detained in a prison formerly run by the KGB. He's now been allowed to return home, but he remains under investigation. At the time of the extradition, at the time of the warrant, the Hungarian authorities assured the UK courts that they were ready to prosecute. They were trial ready. This wasn't a hit and hope, they were trial ready. And yet 6 years after the alleged offence took place, Mr Turner has not been charged with any crime whatsoever. The extradition that threw his life into turmoil was little more than a hit and hope fishing expedition. There's no other word for it. And again, the Baker report remains oblivious, if not blind, to the basic injustice, the human toll that that kind of ordeal takes on those affected. Not just the victims, but also the families. I give way.